Okay, time to begin panel 3. Thank you for joining us today for panel 3. My name is Giovanna Gismondi, and I am a visiting associate professor here at GW. Panel 3 will explore how investor state tribunals handle human rights and environmental issues. And so for purposes of the discussion here, we're going to discuss two cases. One is Renko versus Peru, which is an investment arbitration case. And we're going to discuss, in addition to that one, another case, La Oroya Community versus Peru, which is an international human rights case. And so those are the two basic cases that we are going to discuss to give you an example about how tribunals handle environmental concerns, environmental issues, breach of environmental law. We have a group of panelists, all of them experts in intersectional issues between IIL and international investment law and environmental law. So I have to my left, John Giovanni Hewitt. John is a partner at Queen Emmanuel. Then we have David Atanasio. David is a partner at Womble Bond Dickinson International Dispute Practice. And then we have Ian Laird, who is a co-chair of the International Dispute Resolution Group at Crowell and Morin. So we're going to begin with David. David will provide an overview of both cases, and then I will present questions to the four panelists and give them the opportunity to talk about at least intersectional issues. So David, the floor is yours. Is that working?
I think that's works.
Okay. Thank you. Good afternoon. Thank you, Giovanna. It's a pleasure to be here. I really appreciate the invitation to speak. I always find this set of issues to be absolutely fascinating, the collision of systems, how we resolve those issues. And before my career in international arbitration, which is my primary area of practice these days, I spent several years researching and teaching human rights abroad. When I transitioned to my current field, I actually was promptly put to work developing legal arguments for a case that raised not exactly the same issues as we're going to talk about today, but the collision of indigenous community rights and investor rights in a case related to a South American state. And a major part of our defense, I was representing the government in this particular case, was the fact that the state had indigenous rights obligations and that the investor in this particular case had violated those obligations. So coming out of that experience, though, I was a little bit surprised that the tribunal, the investor state tribunal in this particular case, was not more receptive to our arguments. I mean, having been focused on human rights for a number of years before, it seemed kind of obvious to me that you should pay attention to the rights of indigenous peoples when you're deciding an investor state award, but I was new to investor state arbitration. That would seem less surprising to me today. So in the subsequent years, decade, I've become increasingly interested in this set of issues of how investment law should and could and does interact with human rights law. And to a large degree, this is sort of an abstract issue. I mean, it's an issue that sort of in practice comes up. I mean, almost every large industrial project, mining project, oil and gas project will have some issues of the relationship with local communities, their impact on the local environment. But it's rare that you actually have parallel court proceedings. So that's why I find the cases that we're going to, or well, actually not court proceedings of the investor states arbitration, but that's why I find this pair of cases to be so fascinating. So what I'm going to do in the next few minutes is give a brief overview of these two cases, Renko versus Peru, and La Arroya versus Peru. And they'll be the sort of point of departure for our discussion today. We won't necessarily be all focused on the specific details of these cases, but I think they'll provide sort of an illustration and sort of an intuition pump for our thinking about how these two systems of law interact. So what are these cases about? Well, what's so interesting about them is they actually arise out of the same set of facts. And I'm just going to start with a little bit of a background here. So they both relate to a smelter in La Arroya, Peru, that goes back over 100 years now. And this smelter was first created in 1922 by a US-based company, Cerro de Pasco Copper Corporation, and it created this metallurgical complex, the La Arroya Metallurgical Complex, which processed a wide range of metals, but including lead, copper, and zinc. In 1974, this metallurgical complex was nationalized and then operated by Peru for several decades. Political winds apparently changed in 1997 in Peru, and they decided to reprivatize the company. And then in 2009, operations at the smelter were suspended for financial reasons, and in the subsequent years, the operations have apparently partly resumed. Now, the crux of the problem in both of these cases, both Renco 2 versus Peru and La Arroya versus Peru, is that metallurgy and this metal smelting is sort of a dirty business. I mean, it's just intrinsically produces a lot of pollution. According to the data reported by the Inter-American Court of Human Rights in 2006, La Arroya, the city in Peru, was listed as one of the most 10 polluted cities on the planet. And the plant's activities affected an area of over 30,000 hectares. So, and for many years, many years, until the early 90s, there were limited or no environmental regulations applicable to this metallurgical plant. Finally, in the early 90s, Peru did adopt some environmental regulations, and so started to shift and impose some restrictions on the activities. But of course, when you've got a plant that at that point must have been, what, 70 years old, it's a little difficult to pivot it to a cleaner form of operations. In 1997, right before the privatization, Peru and the plant adopted an environmental adaptation and management program. And then right after that was adopted, it was sold to the parent company, Renco. So we have two cases that arise out of these sets of facts. The first one is the La Arroya population versus Peru, which the Inter-American Court decided in 2023. And the core of this part of the dispute was whether Peru had harmed the local populations around this plant, and whether it had taken adequate steps to protect the local communities from the massive amounts of pollution that were allegedly coming out of the metallurgical complex. And this is true, and it concerned both Peru's actions before the privatization of the plant and afterwards. The rights at issue in this case were broad spanning. I mean, really the crux of it is, I would say, right to health and a healthy environment. But the Inter-American Court tends to take a very expansive approach in many of its decisions and analyze this under also the right to personal integrity, to life. Some people have actually died from the pollution, the right to childhood, and others. Perhaps unsurprisingly for those of you who are familiar with the Inter-American Court's operations, the court found against Peru. It's pretty rare for a state to prevail in this, and including because there's a prior level of screening before these cases get to the court. And it found in a detailed decision that Peru had violated all of these rights, both before and after the complex was privatized. Among other things, the Inter-American Court considered that the state had violated its rights specifically by failing to adequately supervise Doe Run, the local operating company for the metallurgical complex, but that was owned by Renco in the United States. And it failed to adequately supervise this, including by granting Doe Run extensions on certain deadlines for compliance with that environmental plan that they had adopted before the complex was privatized. I mean, so this is an interesting decision, maybe for a number of different reasons. I'm not going to even begin to try to touch on all of them, but just first, I mean, we've got a very clear statement of this, that the state has an obligation to regulate the conduct of private parties, and that it has this obligation specifically in the context of environmental harms. And I just do want to underscore again that the court specifically found that giving extensions to compliance was itself a violation of the American Convention, and that's a point we'll come back to in a minute. So the decision is 200 pages plus long. There's many things you could say about it. The Inter-American Court tends to be quite nuanced and lengthy in its decisions, but I think at a high level, that's sort of the crux of what was decided in that case. But I want to add just one note that I found particularly interesting coming out of this decision from the Inter-American Court. Never one to shy away from groundbreaking statements. The Inter-American Court observed that international environmental protection requires the progressive recognition of the prohibition of such conduct as a peremptory norm, jus cogens, that will gain the recognition of the international community as a whole as a norm from which no derogation is permitted. Perhaps a good statement, perhaps where we'll end up. I would also suggest that it may be a pretty bold statement, but that's sort of the character of the Inter-American Court. So now our other parallel case, Renco 2 versus Peru. This is an investor state case. It's brought under the Peru-U.S. Trade Promotion Agreement, which is, well, it's an international trade agreement that covers a lot of things, but one of the things it does is it provides certain protections for foreign investors. And this case concerned pretty much the same facts, or at least some of the same facts, that gave rise to the Inter-American Court case in La Arroya. This case was brought by Renco, the former owner of Doe Run, and in the case, it alleged, among other things, that Peru's unfair refusal to grant Doe Run extensions on compliance with its environmental obligations ultimately caused the company Doe Run to enter into bankruptcy and thereby destroyed Renco's investment in Peru. So it was trying to hold Peru internationally responsible for this. In the public materials, which in this case are actually quite extensive, all the pleadings are published, Renco primarily focused its attention on a refusal by Peru in 2009 to give an extension to compliance with its environmental obligations. It said that this took place in the midst of the global financial crisis, when it could not actually complete its supposedly final obligations under the environmental plan for financial reasons. There was actually a parallel contractual proceeding here, and in that parallel proceeding, it sort of pled force majeure. But it explained that Peru's refusal to grant it extension prevented it from obtaining financing and pushed the company ultimately into bankruptcy. So I think it's quite notable, just for the sake of our discussion, the Renco Tribunal, the Investor State Tribunal that's going to be evaluating, deciding upon these allegations by Renco, still has not yet delivered its decision on the merits. So we don't actually know how this case is going to come out. But one of the reasons it's particularly interesting, other than that we have parallel proceedings in that it's considering the same facts, the tribunal in Renco also required specific briefing on the Inter-American Court judgment, which the parties delivered last summer. So with that, I will conclude my opening overview of these two cases.
Thank you very much. Thank you. Is this working?
Right, I think it can talk.
Okay, thank you. So thanks, David, for the overview of Renco versus Peru and La Oroya community versus Peru, which are, as David said, two cases that arose out of environmental devastation in the central region of Peru. And these two cases are parallel international proceedings, but parallel under different international agreements binding on Peru. So the Inter-American Court of Human Rights has issued a judgment in 2023, and the judgment is extensive and mandated Peru to adopt a number of measures, including remediation measures to repair the environmental harm. And the court has also made a number of statements, which you're free to expand on. But my question is concerning the judgment of the Inter-American Court of Human Rights, which, by the way, is the second environmental decision of the Inter-American Court of Human Rights that doesn't deal with indigenous peoples. So my question is, what do you think about the impact of the judgment of the Inter-American Court of Human Rights for the region, for the Latin American region, whether it will have any impact, whether governments will pay attention to the decision of the Inter-American Court of Human Rights? Anyways.
Thank you, Giovanna, and thank you, David, for the summary. And thanks to all of you for being here. I want to back up a little bit and just say what an interesting day it's been today, listening to all of the panels and to Professor Anaya's lecture today. I think in terms of answering this question, I want to talk a little bit about one of the themes I think that comes out of all of these panels is that the world is quite complex, and these issues are quite complex, and a lot of the discussions about these issues are simplistic, and some of the solutions we have or that exist right now perhaps are too simplistic. So when we think about international arbitration, for example, we have a community of international arbitration practitioners like me and David and Ian, who, not necessarily us that we're out there supporting it, but the general international arbitration community says things like that international arbitration investment treaties promote investment, it provides rule of law. And then the opposition, as you also heard this morning, say things like it's the global north imposing their values on the south, that these are secret tribunals imposing their will, that these are undermining indigenous communities and human rights, and contributing to regulatory chill. But there are also countervailing factors or issues like the fact that I think it was Patrick's noted that international investment treaty arbitrations are public, and so they're not actually secret in that sense. And then also that in some ways these tribunals and international arbitration as a part of the system of international law, it also does contribute to the extension of the rule of law and promotion of those values. Because one of the things in investment treaties, if you actually read them, they don't say things like, I don't know, ensure investors reap huge profits and undermine the environment. I mean, they say ensure that the state must provide or must not violate the obligation of fair and equitable treatment, for example, or to not expropriate. I think most of us can agree that a government that comes in and takes your house and land for no reason, without any explanation and no due process, that's something that is unfair and that you would hope that you would have redress. at a basic level, that's what the some of the rights that these investment treaties are trying to protect is due process, right to be free from discrimination, things like that. Of course, there have been decisions that have provided or have tribunals have awarded quite a bit of damages, sometimes billions of dollars. And if you think about a country in the global south, or really any country having to pay taxpayer dollars, perhaps for the mistakes of prior administration, that also seems unfair. There's also, Professor Anaya also brought up complexity in terms of indigenous peoples, because, what is this? It's not necessarily the case that indigenous peoples are always harmed by development and foreign investment. And sometimes the communities welcome this investment, want actually the development, want the jobs. But of course, there must be protection for rule of law or for human rights and a recognition of indigenous peoples, not necessarily as just anachronistic back in a particular frozen time, but can also be agents and in their own development or development of a country. You're also seeing a lot of this pushback of ISDS, particularly in Western states like Europe and the US, come from these countries realizing that they also can be, the bilateral investment treaties are two-way documents. So it provides reciprocal protection. So it's not just protecting investors from the global north investing in the global south, but also it's about capital exporting wherever that capital comes from. So it could be an Argentinian investor in France. If there's a bilateral investment treaty, it goes both ways. A French investor in Argentina, Argentine investor in France. And I think at the very beginning of the development of this system, there wasn't as much of a thought, I think, in the global north about the ramifications of such reciprocal protections. So that gives rise to some of the pushback. I think going to your question about we have Inter-American human rights system, and then we have investment law system. They're both meant to protect different things. So one is looking at the treaty, human rights instruments, and that's their mission. They're charged with that mission. And then in international investment law tribunals or investment treaty tribunals are looking at the treaty as the source of law. Now, it is very interesting where tribunals, there's obviously these spheres don't operate in isolation of each other. And so there is interest, I think, and it's, particularly in this particular case of how should the tribunal deal with this other system that based on something else, similar fact or same fact pattern, but they're looking at this and then they're looking at the investment. How do you reconcile that? And our current system, there isn't like a world court or a world authority that regulates this whole thing. So you have this patchwork of some human rights enforcements. You have soft law. You have these initiatives like responsible business conduct, and then you have these patchwork of international investment treaties that are between a bunch of different states. So as to whether or not the effects on other governments, I mean, the other governments in the Inter-American system, of course, are part of the system, so they have to be aware of they're certainly looking at this decision and how that might affect them. But then also, most of these countries have also signed their own investment treaties as well, and so they're also thinking about how do we reconcile our obligations under those treaties.
So just to add a point to your question, you know, how does, what the impact is this on the inter-American states? I mean, to the point that Don was just making, it's my understanding, you know, they've signed an agreement here, it's binding on them, and they've accepted the jurisdiction. So I would think, and you know, I'm not a Peruvian lawyer, but I suspect they're looking very hard at this decision in terms of how they move forward, as would all of the other signatories to the treaty. Or to the convention. I note, and this goes to David's point about the nature of the court and the statements they like to make, but just after the statement that David cited, they go on to say, third, each state must adjust its conduct and refrain from any practice, act, or omission that violates this norm, the norm of jus cogens with regard to the environmental protection. Otherwise, it will incur international responsibility vis-a-vis the rest of the community of states and will be unable to invoke its status as a persistent objector. So the court has a very settled idea as to the impact of its decision. I'm, as I said again, I'm not a Peruvian lawyer, but I suspect that international law plays an important role in Peruvian law, and this is something that's going to have some impact.
Okay, so moving to my next question, we have here that there are two courts, one the Inter-American Court of Human Rights and the other one a tribunal dealing with the dispute under the U.S.-Peru Free Trade Agreement. And in both cases, the environmental issue is very strong, right? The environmental component of the dispute gives rise to two international disputes pursuant to two different international agreements. So given that the investor state tribunal is currently dealing with the dispute, my question is whether the investor state tribunal should look at the findings of the Inter-American Court of Human Rights, which has already dealt with environmental evidence, and import the findings, the environmental findings, into the ISDS dispute. What do you think? Is it possible?
Well, I think it's possible. It's interesting. In this particular case, Peru, of all parties, actually, which I think overall might benefit from the findings, strangely enough, of the Inter-American Court when it comes to the RENCO arbitration, because ultimately it's having to defend the various actions it took to some degree maintain the environmental obligations of RENCO against RENCO's claim that Peru is being sort of unreasonable in doing so. So, I mean, being able to point to the findings of fact that the Inter-American Court has reached, I mean, it's a powerful potential tool, because the Inter-American Court doesn't really pull many punches. I cited one particular statistic that the court reports about how polluted the city was, and I mean, you know, there's pages and pages of this type of stuff in the decision. Strangely enough, though, Peru actually argued that, made I think a point that at least bears consideration, that it's a little unfair from a due process perspective to adopt the findings from the Inter-American Court, the factual findings, because it didn't have the same parties. Now, I say it's strange because, well, Peru was one of the parties to the Inter-American proceeding, so this is an argument that would really sit better in the mouth of RENCO and not Peru. But let's just suppose RENCO had better counsel in this case. I would have thought that would be a fairly sensible point for it to make about the findings. On the other hand, I mean, you have a court, so should they be binding? Probably it would be unfair for that reason alone for them to be binding on the tribunal. On the other hand, should a tribunal give them significant consideration? I would think so. I mean, the Inter-American Court is a sophisticated international body with some authority, with complete authority over its state parties, and some prestige and renown even in the region. It's so as sort of a, as it is, a pure international tribunal that composed of experts, seems sensible to give it some weight, especially given that the court gave this matter very, very careful and extensive consideration. I mean, the factual findings, Dawn and Ian can correct me if they feel this is different, if they feel differently about this, but I would say that the extent of the factual findings and the nuance of the factual findings in this particular Inter-American Court decision are go quite a bit further than what you see even in your typical investor state award.
I think just to add to what David was saying, I was going to mention the due process issues because the parties aren't the same in the two cases. The legal instruments also not the same. So, but in terms of factual findings itself, I mean, as to the question of binding or not, I think you would be hard pressed to find an arbitrator who would say that it's binding and they can't, that they can't look at the facts anew in their own in the investment treaty case, because that's what they're charged to do, is to decide the case before them. But whether or not they should give it due concern or not due process, but give it some weight. Certainly. I mean, the thing that's interesting about international arbitration, and I think that this goes to some of the critiques of it in terms of the secrecy, is that there's no binding precedent on tribunals. So tribunals have quite a bit of flexibility and freedom to decide in the way that they think most fair. A lot of arbitration practitioners often talk about awards being just, they're splitting the baby because they're like, well, a little this, a little that. Okay, fine. So if a tribunal finds it persuasive, they can use it. If they don't, they could talk about it in the tribunal and then decide not to put it in the award. That's the part that the deliberations of the tribunal, of course, are not public. But
Can I just add, sorry, just
Sure.
please.
No, I was just going to make a couple observations and tell a little story if I have a moment. I think it's interesting from a factual point of view to note that in this case, the Inter-American Court decision didn't come out till I think late in 2023, and then I don't even think it was public until well after the hearing occurred in this case. So this wasn't part of the pleadings of the parties. It wasn't part of the arguments at the hearing, but it did become public after the hearing, and it became the subject of what's called a post-hearing brief in international arbitration. And the tribunal asked for their views. They said, to the questions that we're asking here, what weight should we give this? Like, what is this? How do you view this? And then, do you have any comments? Kind of an open question of, would you like to rely on this in some way? Like, are these interesting and useful to you? And please tell us. And part of the way that the tribunal phrased that is a recognition that the tribunal didn't believe it was bound in any way, to Don's point, by anything the court said. They're separate jurisdictions, they're separate laws. The parties were slightly different. Well, there was some overlap, but Renco was not involved in the Inter-American Court proceedings, nor was the agency of the Peruvian government that had dealt with the project. So that there were, much like in a res judicata type analysis, just wasn't enough parallels to actually say these cases should be decided in exactly the same way. That being said, as David has intimated, there were a lot of factual findings in this case. Many of the same factual issues came up, and arguably that could be very useful to the court. The problem with that, and I face this, and this is the story. I face this in a case involving an Italian claimant, an ISDS case, suing Lithuania over a privatization bidding, procurement process that went bad. And this was, late 1990s, 2000s. And my client initially went to the local courts, exhaustion of local remedies, kind of at its purest. They went all the way to the Supreme Court. They won their case, but their damages were lacking. It was very much a minimal sunk costs kind of analysis. They decided that they'd like to seek a higher level of damages and took Lithuania to court again. Now, the question was asked, and Bridget Stern, who was one of the arbitrators, asked the parties, so how should I take the fact that there's a Supreme Court decision here setting out pretty much all the same facts and the entire case and was in favor of the claimants? How should I view that? And of course, she has a very subtle view on that. And I think both of the parties satisfied her when they said, oh, you don't have to follow that at all. It is a fact. It is, and as with all local law, and it is part of the factual matrix. It's something you have to consider to the extent that it is useful. You can, and persuasive, you can follow it. And certainly because much like the Inter-American Court, we have the Supreme Court of the country that made a number of factual findings about what occurred. Tribunal did feel pretty comfortable saying, yeah, we can agree with that. We can agree with that. But they did it after hearing the evidence and after hearing the witnesses and deciding for themselves. And I think that's the critical question here for the Renko Tribunal is that, and this frankly goes to the ability to challenge their award, they have to demonstrate that they did their job and that they're not relying on another court or another entity or anybody else to make their decision. That being said, obviously a very powerful decision, lots of information, something that I'm sure they're looking at very closely.
Can I just add one? I just wanted to throw out the perspective from the other side. And I'm not going to actually, I'm an arbitration lawyer, not a human rights lawyer, just moonlight sometimes. But I do want to raise the question of what would the Inter-American Court say about this issue? I think, what would the Inter-American Court think that that an investor state tribunal was bound by its factual findings in this case? I don't know the answer to that. I'll just leave that for people's consideration.
Well, it's interesting, just how courts view each other differently is always the bane of existence in public international law. And I know Alain Pellet wrote an article a few years ago bemoaning the fact that the ICJ completely ignores all of the jurisprudence of the literally thousands of ISDS cases out there, and making the argument, particularly with regard to certain issues around, nationality and then definition of investment, particularly cases like Barcelona and Diallo, kind of saying, you should be paying attention. There's a lot of very smart tribunals dealing with these issues. And that was one of his laments, is that the ICJ is very much focused on what it does to the exclusion pretty much of other institutions.
Maybe just on that, just a quick point is that Ian's point illustrates, I think, that this whole entire system is there are human actors involved at each level. So if you think about the human ego, humans on tribunals thinking in a system where there's no obligation for them to accept the decision of another court or another tribunal, or similarly with the ICJ, with ICJ judges, certainly they wouldn't think as from their human ego perspective that, wait a sec, why would this investment tribunal, why should I give that any weight? So I think that there's a human element to this all, and that there's human actors in this supporting, kind of also looking at what they're supposed to be looking at and what their charge is. But it's difficult because, like I was saying, the whole thing is it's a patchwork. It's not an entire unified system where all of these issues can be litigated in one sphere. And so it's it's unsatisfying because there's not a way to have all parties have due process in each, at least the way that the system is set up now. And a lot of the reform initiatives and a lot of the destroy arguments are because of that dissatisfaction. And so it's incumbent upon activists and those of us in the system and those of us who are studying the system to come up with solutions, because clearly there's a massive discontent with the way it is now.
Okay, thank you. So I had more questions about the case study today, but we ran out of time. However, I have one more question, but with 1 minute answer. No more. So my question is, and it's unrelated to Renko, but my question is, in investor-state dispute settlement, the system has been criticized for being a self-contained regime that disregards environmental law, environmental values, international human rights law, international environmental law. So my question is, what is the impact of breaching environmental law, those domestic environmental law, in the context of investor-state arbitration? Does breach of environmental law impact the outcome of an investor-state arbitration? Do we have the answer?
I think the answer is complicated. It would depend.
Okay.
Yeah.
Are you talking about by the investor or by?
I mean, when there is breach of national law, how does the tribunal look at breach of national law? We're talking about an international tribunal that is created pursuant to an investment treaty that has very limited jurisdiction, which is to determine whether the rights of the foreign investor pursuant to the treaty were violated. So, however, the investor may be involved in violation of domestic law. How does violation of domestic law impact the outcome of that dispute?
Yeah,
Is that
just
clear?
give maybe a couple different ways in
Okay.
which it could, at least from my perspective. Now, this has never come up with environmental law, as far as I'm aware, but other breaches of domestic law sometimes deprive an international tribunal of jurisdiction over the dispute. That tends to be more things like fraud or corruption, at least historically. But I suppose if you had a really, really serious breach of environmental law that went to the creation of the investment, that might be a consequence. In other cases, breach of environmental law might serve as sort of a factual justification for what the state has done and that the investor is complaining of in the investor-state arbitration. So, I mean, at least those are two different ways, but how those would play out in practice really depends on exactly what type of environmental law, what type of breach we're talking about.
Okay.
Yeah.
So that means that the International Investment Tribunal is not actually disconnected from national environmental law. In fact, they will look at national environmental law to determine whether the rights of the foreign investor were violated. I mean, the rights of the foreign investor pursuant to an investment treaty. So national law actually plays a role as a fact. I mean, if the investor claims I was unfairly treated, but at the same time, the tribunal finds that the investor breached environmental law, that breach may have a role in the determination whether the investor was treated unfairly. Isn't that correct?
So just, so the investment treaty doesn't necessarily, the investment tribunal wouldn't necessarily be looking at, or let me back up. Investment tribunal is looking for violations of the treaty, which is of the state's obligation to provide fair and equitable treatment, not expropriate. All of the actions of the investor come up often in the state's defense. They say the reason why we revoked the permit is because X, Y, Z, and therefore it's legitimate, and therefore that's why there's no liability. The state doesn't have to pay. So it comes up in defenses, it also comes up in counterclaims and mitigation of damages. So a state might counterclaim and say, and this of course always depends on the treaty, but counterclaim and say, well, actually you caused all this damage and so you need to pay. And then tribunals will sometimes, so some tribunals have looked at that as a mitigation of damages, so reduction of damages, or they'll do, an award to both parties ends up being, usually still, if there's award to both parties, it's the claimant. That means that they're winning in that case. But it does come up in that way. And I'll say generally, national law is almost always a factor. I mean, in almost all of the investment treaty arbitrations I've done, we have a national law expert of some sort, because the fact that the government violated their own procurement procedures or whatever, their whatever due process that they provide, or whatever it is, there's always some sort of a factual background. The national law portion of the case it goes into the kind of like factual issues, even if you have an expert talking about the national law issues. So it would be if environmental law, if the breach, so coming from the environmental law perspective, if the breach of the environmental law isn't brought up by the state, then I think that's where third-party submissions are important, because then they're actually going to be, hopefully the state is represented by good counsel, so they will be bringing up these sorts of issues. But if not, hopefully third parties. But if nobody considers it at all, then the tribunal likely wouldn't be looking at it, because it wouldn't be what they're.
Okay, questions? Any questions about investor state arbitration and how tribunals deal with human rights and environmental issues? Questions about rainfall? Yes, Byron.
Hi, my name is Byron. I'm from the International Comparative Law Program, and thank you for the wonderful insights. I had a short comment, from David. Since you mentioned the Gloria case where it was held that, Peru violated the human rights violation because it failed to protect its citizens. So how would, investment law treaties be reformed to prevent, cooperation from violating, climate or public health measures in the arbitration claims? Because historically, we have seen that the IETs or free trade agreements have focused more on the investor rather than environmental accountability. So how can those treaties be reformed in that perspective?
Well, I mean, I think this goes to what Dawn was commenting on how the system is somewhat fractured, in that we have, there's the Inter-American Court, which actually you could ask the same question of that. There's not really a space for investors there either. So you have one court that's looking at these issues from the perspective of human beings writ large, and then another that's looking at it from the perspective of investors. And so so to your question, well, I'm not sure that as the system is currently constructed, an investor state tribunal is really necessarily an ideal place for say holding a company liable. If you want to hold a company liable as a state, you just, send in your environmental regulators and impose fines or whatever it is you do in your local system. The sort of the function of investor state arbitration tends to be the fact that investors don't really have any, whereas a state has recourse against investors because, while they're in its territory, the investors don't really have recourse against the state. I would say though, and just sort of building off of your point and your question, there is a serious issue about how and to what degree an investor state tribunal ought to take environmental considerations into account. I think the Renco versus Peru case has us to at least in one of its sub issues. The Inter-American Court says that Peru had an obligation not to grant extensions to this compliance with this environmental plan. Renco complains to the Investor State Tribunal that Peru's failure to grant it extensions was a violation of its rights under the international treaty. Well, what is an Investor State Tribunal supposed to do with that? I had we unfortunately ran out of time. I had some remarks prepared on this, but I think the short answer is that it's a little difficult to know from current international law what the correct approach to thinking about this is, and how you sort of bring these two sets of, I think, well, let's say important values. I suppose different people in this room may have different ideas about how important the values of the investor state arbitration system are versus human rights, but you have these two different sets of values that are protected by these two different systems. Let's suppose both are important. How do you reconcile them?
And one other thing that states are doing, not so much to hold investors accountable, but to provide themselves more flexibility, is writing into their newer bits or reforming older bits, making more explicit their right to regulate, essentially. So, and particularly in the areas of health, environment, national security, and making that more explicit. So,
Yes, please.
Yeah, thank you. My name is Saul, also an LLM student here at GW. And I wanted to ask you if you consider the constitutionalization of investment arbitration as a tool to resist enforcement, especially dealing with environmental law violations or environmental breaches.
if the Constitution, right?
Just a clarification, when you say constitutionalization
Yeah,
of
so-
what?
Yeah. I'll elaborate a little bit more. So in Latin American jurisdictions, we have a tendency of using some sort of resources like amparos or telas in order to resist enforcement. Do you believe that a breach of environmental law can lead to the prospective use of one of these resources?
I think, well, the issue of amparo is more of a domestic law issue. When we talk about resisting enforcement, and actually this was one point, just a educational point in terms of one feature of the international arbitration system and why those who are proponents of it like it so much. It's not just that international investors can go into, they don't have to sue the country in their own, home state where, the old way, the traditional thinking was, oh, well, they're, it's corrupt there. Would they want to have a international body? But also because of the New York Convention, which is, I think, the most signed signed onto treaty in the world at this point. Nearly every state is a signatory to the New York Convention. The New York Convention allows anyone with an arbitral award to take that award and enforce it any place that in any country that has signed the treaty. That makes international arbitration quite strong and even stronger than a state court judgment, or like a foreign court judgment, for example, because there's a presumption of validity in all of the New York Convention states. And in terms of resisting enforcement, it's really only based on very, very few and enumerated factors, like it was like the arbitrators were conflicted, or there was a violation of public policy. It's meant to be a very narrow exception so that it's a presumptive validity of the, but in terms of, there actually was an interesting case where I think it was, there was an amparo in Mexico, and then in the US, they were trying to enforce it, and the US looked at the Mexico judgment and said, well, that doesn't, similarly to what we were talking about earlier, they were saying, well, that's fine that the Mexico vacated the award. Doesn't matter to us. We look at our own, we look at the facts ourselves and enforce the judgment. So,
Yes. Hi, please.
Yes, Yeah, I have a question regarding the point that you made in terms of there's like some flexibility in arbitration, some there's like if there's a compelling point or a persuasive point, the tribunals can like incorporate those criteria in the courts. However, mostly when like those kind of concerns about the environmental protection and the protection of vulnerable population, like the middle population, had made through amicus curia normally, but they were dismissed. Like majority of the cases were dismissed, and they because of like normally the arbiters allege the framework of the case is just like the bilateral agreement and the laws of the countries. And those, like, for example, the case of the Supreme Court, the precedents that they established, or the principles of law, even they are not really considered for resolving those cases. So how do you find, or which one do you think that will be a compelling or an argument, a persuasive argument that they can establish, so they will be finally resolving, considering those principles of international law, or like the principles that for example, the Inter-American Court has already established with their case.
Well, in general terms, investor state arbitration tribunals can accept amicus. However, depending of the particular treaty and whether the treaty says that the tribunal has jurisdiction to consider amicus. And the amicus normally raises environmental concerns, human rights concerns, the concerns of the communities, and so on. The impact of the amicus, because I've made a survey of the impact of amicus in investment arbitration, and I found that it rarely impacts the outcome of investor state arbitration, which is basically made pursuant to an investment treaty. On the other hand, another aspect of your question could be the jurisdictional powers and the applicable law of the tribunals, because tribunals are empowered to enforce the treaty, the investment treaty, and applicable rules of international law. But the interpretation of applicable rules of international law is very limited in investment arbitration. So it wouldn't bring the decision of the Inter-American Court of Human Rights into the ISDS dispute. It wouldn't bring the ICCPR or the Inter-American Convention on Human Rights into the investment treaty arbitration. That interpretation of applicable rules of international law, which usually appears enshrined in an investment treaty, has been interpreted very, very limited in investment arbitration. So the channels that we have to import international human rights law into ISDS are very limited, or there's no way to bring those judgments or decisions into the investment arbitration treaty for those reasons. I think I answered your question. I hope I did. Do you have any other question?
Somebody,
There's a
they're
few
pointing
back
to somebody.
Yes.
I had a question if there is the new generation treaties have numerous for example, talks about exceptions, the measures necessary to mitigate climate change and so forth and so on. So by necessity, tribunals would now have to consider what these other treaties say and what they are. And I would love to have people's thoughts on how well situated tribunals are to look at the obligations like other treaties. And if you have any thoughts on what a good process would be, sure that the relevant expertise.
I think it's doable. It's going to create more work for the parties and certainly for the arbitrators. The arbitrators tend to rely on the parties' submissions in terms of, if there are specific, decisions or treaties or law that implicates what's going on in the case. I think they'd expect to be briefed on it. So that is in the normal course of the judicial or, decision-making process. You put it before us, you tell us why it's relevant, and we'll consider it. So I don't see that as a problem. Yeah, it certainly could create more work for lawyers.
Yeah.
But apart from that, it seems something that the negotiators of those treaties have taken into account, and it seems entirely reasonable.
And just to add, I mean, not only, I think I would expect that states would make every effort to take advantage of those sorts of provisions in an appropriate case, to argue it as a defense, and they'll put forward their experts. And I mean, so you would get, I would expect you would get actually in practice full briefing on these things. And
Yeah, and if I could just add, one feature of international arbitration that I think investors like and parties like is that, generally speaking, the arbitrators are quite knowledgeable, and they're people who are at the top of their profession. I think somebody was talking about dual hatting before, but and another person talked about, for example, in Mexico, and we have this in the US as well, where with the Mexican judicial reform, all the judges will be elected. Of course, when you have election of judges, it doesn't necessarily mean that you're going to have very knowledgeable or educated or appropriately aware of legal obligations. I mean, it's an election, so to the extent that you do have these sophisticated actors who are, most of these, or a lot of these arbitrators speak many languages. They've lived in a lot of places. They're very aware of different legal traditions. The fact that they're working in international arbitration means that they have seen civil law traditions and common law traditions and different ways that states have resolved and resolved conflict, have regulated their own industries and investments. So you do at least have smart people, usually, or by and large smart people in these tribunals. And then just to bring up, just to add on to what Ian was saying in terms of briefing, because of course arbitrators would ask for briefing and the parties would probably want to brief it. And all of that, what that means functionally is that it becomes more expensive, and there is an access to justice component of international arbitration. It costs a lot of money. I mean, all of us have very high billable rates, and it's not cheap now to defend or to litigate one of these arbitration cases. We could talk. There's a whole other issue of access to justice and third party funding, and how smaller actors can get access to the system. But that's a feature that's worth mentioning.
Marcos Orellana.
Thank you. An earlier case of the Inter-American Court of Human Rights involving indigenous peoples in Paraguay decided that the court pronounced that the American Convention on Human Rights superseded or any bilateral investment treaty that Paraguay was a party to. So in the hierarchy of international law, as the court sees it, human rights is above bilateral investment treaty protections. In the case of La Roya that you're commenting, the court could not have been unaware that there was an arbitration going on, and yet it remained silent. Take the opportunity to reaffirm this position, make anything of that, and otherwise, do you see anything in the operative part of the decision that could have an implication for the award?
well, I guess I can comment on that. I mean, one reason possible, so I don't know the reason why I didn't repeat referring to the comment from Sawaya Masa versus Paraguay. I don't know the reason why it didn't repeat that. It actually occurred to me last night as I was preparing for this. And I tried to look just to confirm. But one possibility is that it just wasn't argued by Peru in this case, and so there might not have been an occasion to actually have to make a comment on that. Then, yes, let's see. Well, sorry, remind me of the second part of your question.
The second part is whether there was anything in your reading of the appellate part of the court's decision that could perhaps have an implication for you.
Well, I mean, the one thing I did think that might have an implication is, I mean, the court did in its reasoning point to the fact that that Peru had given extensions to compliance with these environmental regulations. It pointed to that fact as a violation of the American Convention, and in the international arbitration, Renco is arguing that Peru's failure to immediately give it an extension to compliance with its obligations was a breach of the obligations under the International Investment Protection Treaty. So, you know, I don't, if I had to guess, I don't know that the tribunal is actually likely to engage that much with this fact, but at least in theory, you would think you'd want to resolve that sort of potential collision of obligations, or at least in very near collision in some sort of principled way.
Do you have any other question? No. Well, thank you so much to my three wonderful faculty. Thank you so much.